I want to see how many transitions Steve can come up with, because that last one was a real masterwork.
Brutal. I'm just going to keep saying, and we're done with that section. On we go. And curtain. That's time, isn't it? My producer's waving me off. The Horse Race is brought to you by Benchmark Strategies, Boston's leading public affairs and public relations consulting firm. To learn more, connect with Benchmark on LinkedIn at Benchmark Strategies or visit benchmark-strategies.com.
Welcome back to The Horse Race, your weekly look at politics, policy, and elections in Massachusetts. I'm Jennifer Smith, reporter for Commonwealth Beacon, and it's Thursday, March 12th. Today we're talking all things ballot challenges. As we hurtle toward a possible record-smashing 12 ballot initiatives before voters in November, several are being challenged at the highest court in the state to keep them off of those very ballots. I am joined today by my lovely usual co-host, Steve Koczela, president of the MassInc polling group, and also my unusual co-host, I don't know if that's the best way to put it, my colleague Chris Lisinski at Commonwealth. Hey guys, how are you?
I'm considering this a promotion for myself from whatever the last military ensign title Steve awarded me was.
Yeah, I think you were something like the Brigadier of Ballot, General of Ballot Questions or something like that. But now that you've been on the horse race 245,000 times, you're automatically promoted to co-host. And I think in second place is probably Katie Lannon at like 190,000. And so she's also drawing near to an automatic promotion.
I don't know. I feel like unusual co-host is both an insult and an accurate description of all co-hosts that we've ever had on this show.
But we do need you today, Chris, because we have so many things that relate to articles that you yourself wrote about topics that you yourself are an expert on. So, yeah, I think 3 co-hosts, this actually feels good. We should do this more often.
Yeah. No, it feels great. A little, triangle of sadness, I guess.
Wait, why are we sad?
I don't know. I feel like I should be
because we're talking about ballot
questions.
questions.
Yeah, exactly. Should I be talking about movies as we head into the Oscars season and just keep it with references that are like 8 years out of date?
I was going to say Triangle of Sadness is like beyond my movie reference land, so you're going to have to update us on that one.
Well, they were sad on a boat, and we don't have time for that one,
Okay.
But we do have time for other types of angst. So do we want to get into it?
Let's do it. Well, it is March. It does seem like November and the voting booth are a long way away, but it is something even more exciting than election season, as I'm told by the fact that it says here in the script, and that is that it's ballot challenge season, which is something we here at the Horse Race celebrate. That's when the proponents of various ballot questions defend themselves in front of the Supreme Judicial Court against opponents of those same questions who file legal challenges of many kinds. So I'm very happy to have both Jen and Chris here to discuss this because there are a couple very interesting ones. So why don't we start with just a basic knowledge question, though, because it seems like if you gain signatures and get the Attorney General's approval to have a ballot question, you would then have a ballot question. But in fact, there's this intermediate step. So Jen, describe what is going on right now in front of the Supreme Judicial Court.
Sure. So basically, what you're thinking about here is almost a timeline in reverse. At some point in November, ideally that first week, I'm told, you will see however many ballot questions actually make it all the way to that ballot in front of you. And so that means if any of them are not supposed to be there, the court has to essentially rule on that well before those ballots actually get printed. And so this kind of means that we have a reverse ticking clock situation. We are in sort of the early to mid stage right now, which is when proponents of the ballot measure have gotten most of their signatures. They've gotten the Attorney General to sign off. They've been told, go forth. The legislature will sort of, kick the tires on a few of these. But, generally speaking, go ahead, do your ballot campaign. But for a few of them, 3 at the moment, there can be challenges saying that this should never have been certified in the first place. It should never have the chance to go to the ballot. And that can be for a few different reasons. So the Constitution basically limits what sorts of things are appropriate for ballot. And that means that a ballot measure, since it's just an up or down vote, is not considered appropriate for things involving religion, things involving the court system itself, or specific places in Massachusetts. You can't put a statewide ballot measure in front of people saying we have rules for air right now. So that's basically one of those rules. And then there's a bunch of fiddly restrictions in terms of how much stuff you can pack into any one ballot measure, and a bunch of other things that we will get into when it comes to the specific measures in front of us.
And we should also note here that some very significant ballot questions in the past have gotten tossed at this point. They've made it all the way through the pretty laborious process up to the challenge before the Supreme Judicial Court, and then did not make it. I'm thinking most significantly recently of Common Core. There have actually also been a couple which got tossed and then came back in other forms. But the three that we're going to talk about today, just in terms of the specifics of the cases that they're facing, are the ballot question on rent control. There's also one on putting all of the candidates on one common primary ballot. And then there's actually one also on the income tax. So in that order, let's just start with rent control. Chris, before we get to the challenge, just remind us what the ballot measure would actually do.
This question would revive rent control, which voters in Massachusetts banned statewide in 1994, if it's worth noting. And it would not just revive it as a local option. This would impose a strict cap on rents in every single city and town across Massachusetts for covered buildings. It would not allow rents to increase effectively more than the rate of inflation every year.
All right, and then from there to the challenge, Jen, what are opponents saying is wrong with this ballot question that means the Supreme Judicial Court should disallow it from appearing on the ballot?
So the challenge is being brought by a group of folks that you might expect. So this includes, business and real estate interests, but it has to be brought under the names of a few individuals here. So 4 landlords who own and lease residential units in Massachusetts are the actual named plaintiffs in this case that's in front of the SJC. And they make 6 different arguments for why this should not have been certified in the first place. So on kind of a very basic initial level, they say that the petition contains undefined and ambiguous language. So basically that people wouldn't understand what they were voting on here. It basically tries to argue that the Attorney General's summary of it, not just the language itself, is misleading, incomplete, and not fair. Fair in like a legal sense, not fair in the way that, a child would use it on the playground. Because this group argues that the summary that the Attorney General presented to voters does not say that the petition goes beyond just proposing a new rent control law. So this is kind of an interesting legal argument here. They're saying actually it's trying to strike out that current law that prohibited rent control, the one that Chris referred to in 1994, and propose this new law. And then they also decided to attack it by saying that this is essentially an unconstitutional taking, that they're preventing landlords through this ballot measure from receiving the compensation for their property that they should be entitled to. Basically, if you're limiting how much they can increase the rent, you're limiting how they can profit from the property that they own without compensating them appropriately. And then they also say, and this was the one that really kind of had me cocking my head, that it shouldn't be allowed because, as mentioned earlier, it involved religious matters. Now, the argument that they're making here is that it involves religious matters, and I see your face, Steve, and this is why I'm going to explain it. Because it actually exempts religious structures from being subject to this rent control law. And they use the same thing by arguing that by exempting short-term rental units, so the law itself exempts several types of units, and 2 of them are religious institutions and also short-term rental units, they're actually treading onto the unconstitutional territory of a religiously oriented ballot measure and trying to jam too many different things in at once, because by exempting short-term rentals, it is actually regulating short-term rentals. So those are sort of the basic arguments that they're making in the rent control case.
And it's just worth noting there that one of the reasons that other ballot questions have gotten tossed is the unrelated issue basically rule where you can't have, Jen, as you've alluded to, multiple different issues on a yes or no vote, because somebody might want to say, yes, in general, I'm in favor of rent control, but I don't really like this religious, building exemption, for example, or I don't like the way that it treats short-term rentals. So, by and large, the attempt is made to keep one issue as a part of one ballot question. And this is a way that ballot questions often get tossed.
That is such a sound point, too, because one of the things that we should probably acknowledge here is all ballot questions are sort of inherently in conversation with legislators here. There have been complaints in the past, even from proponents of some ballot measures, that they'd actually like them to be able to include more nuance, more sort of discrete, maybe unrelated issues than you are allowed to through the ballot measure process. And the one that's coming to mind here, and I'm sure, Chris, you'll have some things to add on this, is the ballot measure from last cycle that eliminated the use of MCAS, the 10th grade MCAS, as a graduation requirement, and basically just kind of stopped there without replacing it with anything. And so folks who had been saying, well, we'd like to see the legislature move on both changing this kind of high stakes testing rule and replace it with something else, weren't able to get movement on Beacon Hill on that. And so instead, the ballot measure that passes basically eliminated an option without proposing a new one. So Chris, what have you sort of been watching when it comes to the sort of implicit rebuke of the legislative process that comes through these measures?
There's pretty wide agreement that, especially this year when we are seeing a record number advance toward the ballot, and several questions, we should note, that deal with the way that the legislature itself operates, that the unifying theme is frustration with Beacon Hill, a sort of attitude among proponents of, fine, I'll do it myself and go to the ballot because this arguably popular idea has not gotten any traction in the House and Senate. Lawmakers are not happy about that generally. They are, in my experience and in conversations I've had with folks, not overcome with reflection and contrition that they have not acted on X or Y topic. They feel that the entire process has actually been co-opted by interest groups who want something done no matter which way, no matter the cost, and are now exploiting a ballot process to put really weighty, complicated policy matters in the hands of voters, as you note, with less room for nuance, less room for deliberation, less room for compromise.
And we certainly can think of examples of that, including topics that have no possibility of being comprehended by voters, and I don't mean technical things about elections, because voters can get their heads around those. I'm talking about right to repair, things like that, where the things that we're being asked to vote on are just not, we should not have to be like technocrats in order to go in and cast a ballot. But there are two more that we want to get to. So, Chris, you wrote a story about a challenge to this ballot question, which basically would replace the party primary system that we have right now, where Democrats go off to their corner and Republicans go off to their corner and choose their fighter that was going to go through to the general election. And should there be more than one candidate in other parties too, they would also go through. What this proposal would basically do is do away with those multiple contests, and anybody who's running, for example, for a state rep in this particular district would all appear on the same ballot, and then the top two vote getters would move on to the general election. So it would be a big change in both how elections are operated and kind of the power that parties have and so forth. And this has drawn a lot of interest and attention from the people who currently hold that power, as well as now a challenge before the SJC. So, Chris, who are the folks that are challenging it, and what are they saying?
There are two plaintiffs in this case, Martina Jackson and Ann Roosevelt, and those are two significant names. Both of them are veteran Democratic State Committee members. Martina Jackson chaired the party's platform committee last year in 2025. And Roosevelt is married to Jim Roosevelt, who works as volunteer legal counsel for the Massachusetts Democratic Party. So these are insiders. These are people who have long histories in our existing partisan election system and do not want to see it change. Granted, I should note, I talked to someone with the party who said the party itself is not involved in the lawsuit, is not endorsing it or opposing it. This is coming from these two as individuals, but we can't ignore their history and their bona fides as state committee members.
And they're taking kind of a novel legal approach, right? I mean, they're not actually complaining about the impact that it will have on them. They're using other kind of legal theories about what the impacts of this change might be, right?
Yeah, they're actually arguing that the folks who stand to have their rights to free and fair elections violated are third-party candidates who would not have an easy route to the general election. Of course, they could appear in the same open primary as every other candidate, but unlike the status quo, they could not just file as a unenrolled candidate and appear on the general election ballot.
So it's really funny. So as Chris and I were kind of chatting about this in the newsroom, one of the things that was coming up, at least in my mind as a longtime kind of Boston-based reporter, and also a California native, is these models exist elsewhere in different forms. California is pretty well known for its all-party primary, sometimes called a jungle primary system. And so some of the critiques, interestingly, as Chris noted, end up coming from party members, essentially saying, well, if you encourage basically everybody to go in on the primary level, and let's say it's a pretty blue state like Massachusetts or California, and you have a slew of potential more liberal or moderate Democratic candidates, and they end up kind of splitting that vote, you don't have something like a ranked choice voting system where you would still eventually kind of consolidate preferences around someone who represented, say, most of a party. But you could end up in a situation where, because there was just more splitting of Democratic votes rather than Republican votes, you can end up in a state situation where the two people with technically the most votes as a percentage of totals might actually just be two Republicans. And so that's great sometimes for Republicans if they have more of a presence in a state like California as opposed to Massachusetts. But you can kind of see where this becomes an issue for the parties. And then the other thing that came up, of course, was here in Boston, we have nonpartisan elections in general, not just primaries, but nonpartisan elections. So you can end up with very funny situations, as in the last cycle, where Josh Kraft and all of his messaging as he challenged Mayor Michelle Wu said, Josh Kraft, Democrat for mayor. And there was kind of a lot of nodding at that, saying, yeah, man, but everyone that's running for the mayor of Boston and has any real shot at it is some flavor of Democrat, and we also don't have party primaries.
Yeah, Jen, you certainly have hit the nail on the head with the first thing you noted about wrinkles in the system, where you can get two members of the smaller party who advance to the final because of the vote splitting in the larger party. Chris, you also noted that the opposite scenario could happen, where a current Democratic office holder would be running and he and another Democrat would get through the preliminary election. And rather than being in this, safe electoral space that elected Democrats have become accustomed to, he might be running against somebody from the same party who voters really like, or somebody to that candidate's left, or someone to the right, somebody that better represents the district. And it could threaten the sacred right of Massachusetts office holders to get reelected without very much competition.
And of course, then you would have two Democrats theoretically on the ballot in a higher turnout general election when Republicans or anyone else who doesn't pull a Democratic primary ballot also get a say. So it's really easy to see there's a whole bunch of different permutations for how this could change the status quo.
Chris, I wonder actually if you could dive into a little bit of a wrinkle that's come up a lot over the years, but is very relevant whenever there's sort of an electorally focused ballot measure change, as in with ranked choice voting attempts in the past, with this all-party primary one, which is, what do we end up making of kind of the sitting incumbency advantage here that Steve alluded to? What do we do with the fact that Massachusetts has such uncompetitive elections? From how do you report on this with the voter experience in mind here, which is most people are pretty used to getting all the way to the November ballot. Most folks don't end up voting in their primary elections, and they see the two-party options, if there are even two-party options, and just go, yeah, sure, Massachusetts, we're checking that box off. So how is that factored into this debate?
It's a chief point raised by proponents, I would say, as I think the three of us have discussed on this podcast before. We have notoriously uncompetitive state elections. Something like half of the legislature every 2 years is guaranteed another term because nobody runs against them. And granted, you would still need candidates to get in the mix in the first place to upend that, but proponents make competition a central part of the pitch for this because they think a different path to the general election and a different set of options in the general election will change the calculus enough to chip away at that incumbency advantage.
All right, well, that brings us to our third one, which is a bit easier to understand because it's just, should we cut the income tax or not? So, Chris, walk us through what the stakes are here and who's lining up on each side.
The stakes are quite high to the tune of, $5 billion a year. This is a ballot question being backed by several influential business groups, including the Massachusetts High Technology Council, that, as you said, Steve, the text of it is really simple. It would phase down the income tax rate from 5% to 4% over a period of a few years. It's not all that hard to do the math. Look at what the state brings in income taxes now and see what it would bring in with a lower income tax rate. And again, state officials have said $4 billion to $5 billion per year would be cut under this. That has naturally created, I think you can call it an existential panic on Beacon Hill, where folks are already struggling to balance their pretty big spending appetite with the money that comes in. If you take $5 billion out of that equation, it gets a lot harder to continue to fund the things that we do fund.
All right, Jen, so there is the landscape. And what is the challenge that's being posed to this ballot question?
So this one is going to be a lot easier to run through than the 6 different attempts at striking the rent control one. A coalition of civic and labor groups are arguing that Attorney General Andrea Campbell's summary is fundamentally unfair because it is inaccurate and misleading on a key point. And so the key point that they're arguing here is that this initiative proposes to reduce the tax rates applicable to all 3 of these categories of personal taxable income. So they're basically saying this is actually a more complicated question than the summary suggests it is. And because an average voter is probably going to be depending on the Attorney General's summary of it, you can argue that a ballot measure should not be put before voters if the summary is something that is unfair or misleading. So they're taking direct aim at that one.
Something that I think is really key, it's well illuminated by this case, as well as the other 2 cases, frankly, is that the policy debate and the legal debate are 2 different avenues. They occasionally overlap, but for the most part, they are parallel. If any of these 3 questions go forward, opponents will change their tune very significantly for what they say to the public, why you should vote against this. The legal arguments are largely technical in nature, and I don't say that in a bad faith sense, but really opponents are using any tool they have at their disposal, including a technical reading of the Constitution's eligibility requirements, to stop this from going before voters, even if to a layperson it sounds a little suspicious or a little specious on the merits.
Yeah, I think that raises a really good point because you also are dealing with sort of the overlapping timelines. So as we're talking here, the legislature is considering all 11 potential ballot measures through a special joint committee on ballot initiative petitions here. And so that's going to be ongoing at the same time as the SJC is considering whether or not these should be struck for technical reasons. So in the same way that the court is trying to make sure that all of its decisions are out about what is and is not allowed well before anyone basically commits themselves fully to the second half of a very expensive campaign and the period of time where it's going to be kind of most impactful for voters, those months leading up to the actual election. But you also have lawmakers who often have pretty strong opinions about whether or not they would like to see these policies go through, have public hearings that are much more public facing. And because there are so many ballot measures, those are going to stretch for quite some time. But of course, they have to act on it by the end of May.
And to underline that with the point I was trying to make, what you'll hear at those hearings is vastly different than what you'll hear in the courtroom before the SJC. And again, opponents have the right to challenge this on legal grounds. I just think it's important for the public to understand that it is one tool among many that opponents turn to in their attempt to spike a ballot question any which way they can.
Yeah, I think that's the right phrase, is just to get rid of it through any means, any way, which way they can, by any means necessary. And we should also say, Jen, just referring to what you just noted about the parallel tracks, is that sometimes the legislature does resolve like a set of them. There have been a couple times where it's these grand bargains. One of them they actually called the grand bargain, and they resolved, I think it was 3 or 4 ballot questions all at once. So certainly far from certain how many ballot questions will be on that nicely printed ballot when we all get to Election Day, but a lot to keep track of for the next couple weeks and months. We'll be right back.
I'm Zainab Asma-Doyle, Research Director at the Massing Polling Group. The Massing Polling Group serves the region's leading foundations, political groups, government entities, and businesses. Our surveys and focus groups bring high-quality data to the toughest questions facing society today. Learn more at massingpolling.com.
And that brings us to our final segment, brought to you this week by our Unwell Hearts, Minds, and Stomachs department. I have been struggling to figure out what the Massachusetts angle on this one is, Steve, but I am told it is, quote unquote, a matter of art. So, explain yourself once again, Prince Charming.
Yes, this is a matter of art, and even the tweet is a journey, even though it's only a few words. So stick with me here. Buffalo Wild... I can't even speak. Buffalo Wild Wings unveils wing-flavored protein espresso martini.
This is the worst game of Mad Libs.
Not just an espresso martini. It is not just a wing-flavored martini. It's a wing-flavored protein espresso martini. This bit of news was brought to us by the hard-hitting investigative reporting of USA Today, and they said the cocktail is, quote, infused with buffalo dry rub and jam-packed with 10 grams of protein, according to a news release, and that it rides the ongoing protein hype as more and more brands are doing things like this. Apparently, there are protein lattes at Starbucks, protein cold foam, protein pockets at Subway. Chipotle apparently debuted a 4-ounce cup of meat, and Tropical Smoothie launched new drinks with 39 grams of protein. So I guess it's a thing. It's a trend, and we're behind, Jen. That's what I'm doing. I'm trying to bring us all up to date.
Steve, you skipped my favorite line in this story, which is just in time for National Espresso Martini Day on March 15th. Thank goodness, because how would we have celebrated otherwise?
I had no plans, but now I do.
I found a Massachusetts angle here, which is not the Buffalo Wild Wings thing, but the protein thing, because apparently in January of 2026, so a mere 2 months ago, Dunkin' added protein milk to the menu and did a whole thing on how you can boost your Dunkin' coffees with a bunch of extra protein. Steve, I am so happy that you are in Kenya and cannot just show up to the pod bunker bearing, I assume, a Dunkin' protein-laden coffee that you have shoved a single Buffalo Wild Wing into.
If we were doing this in the bunker, I would have purchased one of each of these items, and we would currently be tasting them on the air. That's going to happen at some point. We're going to have the Buffalo Wild Wing, what are they calling it? The Protein-i? Espresso Protein-i. Yeah, so there it is.
Chris, I think we need to do a very hard line. None of these are entering the Commonwealth Beacon newsroom. If Steve walks into the broader Massink offices, we're barricading the door.
Over my dead body.
Well, fortunately for all of you, before one of us shows up with a 4-ounce cup of meat, that is all the time we have for today. I'm Steve Kozelis, signing off with Jen Smith and Chris Lisinski. Our producer and theme music, as always, is done this week by Charlie Kozella. You can write to us at thehorseracepodcast@gmail.com. Don't forget to give the Horse Race a review wherever you're hearing us now. Subscribe to Commonwealth Beacon's daily download for all the latest in protein maxing news. And reach out to us here at the Massing Polling Group if you need polls or focus groups done. For now, thank you all for listening, and we'll see you next week.